Put your hands up your sleeve. Hi.
My judge here.
Great to see you. What's new?
Right from the opening moments, you can feel this courtroom walking into something complicated and emotionally charged. What starts as a routine plea hearing immediately hits a legal crossroads. A serious felony sexual assault case has now been reduced to a misdemeanor, and the judge refuses to proceed without hearing from the victim. And that decision is crucial. In criminal court, victims don't control prosecution, but their voices still matter, especially when deals are being made that permanently shape outcomes. Let's break down what's happening. This case is already 3 years old, reset multiple times, and both sides are trying to finalize a plea agreement today. But without the victim present, Judge David Fleischer pauses the entire proceeding. Why? Because a victim impact statement can dramatically affect sentencing decisions, and conditions of probation, or whether a judge even accepts the plea. And here's where the tension begins. Defense wants closure, prosecutors want resolution, but the judge insists fairness requires hearing the person most affected. This moment sets the emotional and legal stakes for everything that follows. And think about it. After 3 years of delays, should the court move forward without the victim present? Or does justice demand patience even when the system is exhausted? Stick with us, because this hearing is about to shift from procedural to deeply personal. And nothing about this case will feel routine after what comes next.
Judge, this is a plea. It was a felony case. We refiled it as a misdemeanor.
Okay.
And there is a victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I don't want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for them and then we can do it? I mean, take your time. There's no rush.
Judge,
Really.
if I may, this case is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm just.
That's what I'm saying. I'm letting the court know. I think that's kind of unfair to
See
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Can we stand down for a bit?
I'm sorry.
Just stand down to see if she's available to
She
Zoom.
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No, can you reach out to her real quick and just see? I know you're in the home stretch, Jim. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, getting on it deferred. So just give me 5 minutes. Let me see if they can do that. So, guys, please keep it down. If you need to talk, go outside. We have someone that's going to testify here on Zoom. No talking. Mr. Echevarria, can you hear me? So,
Oh, hello. Can you hear me?
yes, I can hear you.
Okay.
Okay, give me 1 second, ma'am. Give me 1 second. So procedurally with this case, Joe, he gets charged with a sexual assault upstairs, or he's on bond for a sexual assault.
Come on.
And then he picks up an indecent.
No. Plea bargain down to a class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was, essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault,
Correct.
to a 2-year defer.
Correct.
Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there
Okay.
something that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you. Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear, confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe.
This is the moment the entire courtroom atmosphere changes. What had been legal logistics suddenly becomes human reality. Victim impact statements are not evidence debates. They're about consequences, emotional, psychological, financial, and social, long after headlines fade. Notice how she describes anxiety, panic attacks, loss of professional confidence, and daily fear. These are not temporary reactions. These are long-term trauma responses. And legally speaking, judges must consider this when deciding whether a plea deal sufficiently reflects harm caused. But here's the complexity. Plea bargains often happen because trials are unpredictable. Prosecutors must weigh whether they can prove guilt beyond a reasonable doubt, while victims often want acknowledgement and accountability, not just procedural closure. You can already sense conflict building. The victim feels unheard and rushed. The system feels ready to move on. And those two realities rarely align smoothly. Let me ask you, do you think emotional and psychological damage should weigh more heavily in sentencing decisions? Or should courts strictly stick to what they believe they can prove at trial? Drop your thoughts below, because this tension between legal proof and personal impact is about to explode in the next few minutes.
And in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't control my heart rates in these moments of panic. There are true anxiety, full-on panic attacks that I experience still to this day, 2 years later. At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income. I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car. And yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulting me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, I ask that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not going to take it. I'm not taking it, Joe. I'm not doing it.
And here it is, the emotional breaking point. She's not just disagreeing with the plea. She's publicly rejecting what the system is offering as justice. But here's the legal reality many people don't realize. Victims do not get to approve or reject plea deals. The state prosecutes crimes, not individuals. So when she says this isn't justice, she's speaking emotionally but legally. The decision rests between prosecutors, defense, and the judge. And watch the courtroom dynamic now. The defense quickly points out procedural fairness concerns, while the judge tries to balance empathy with legal process. The system wants closure. The victim wants acknowledgement and accountability. This is one of the hardest realities of criminal law. Sometimes outcomes feel unsatisfying even when legally justified. Trials carry risk. And plea deals guarantee outcomes, even imperfect ones. Here's the big question. If going to trial risks losing entirely, should prosecutors still push forward if the victim wants it? Or is securing some conviction better than risking none? This conflict between emotional justice and legal strategy is about to shape the judge's next move.
Sorry. Just because she spoke first?
Well, I mean, I don't know. All I know is that we have a powerful victim impact statement here. We have a sexual assault that's being reduced to a misdemeanor, 2-year deferred.
Correct.
Apparently no one's consulted her regarding this thing, see whether they.
We have been in extensive communication with her this past.
No, sir. No, sir. I
About the plea
barely
and
spoke
reasons
to you
for
a
it.
couple of days ago, sir. I didn't even know you were on my case until Tuesday or Monday it was Tuesday when you first called me. I didn't even know Missy was not on my case anymore. And she gave me the confidence that this would go to trial. She believed we had a very strong case to bring this to trial. She didn't have any doubts in this case at all. And I meet Gabe just this Tuesday. And it's rushed into this plea without even without even discussing with me.
Okay. Thank you, Ms. Echevarria. I appreciate your testimony.
I really appreciate your honor letting me speak before you accepted this plea.
Absolutely. And I'm glad that you were here to speak, get everything off your chest.
Yes.
Anything you need, we're here for you, Ms. Echevarria.
I really appreciate that, Your Honor. Thank you for letting me get on Zoom, even though I could not physically be there.
Yes, ma'am. I will accept this, but I'll do 30 days as a condition. It's the only way I'm going to do it. So you guys can talk and see if there's
I
something
think
you
it's
want to
unfair
do.
to my client because normally we do the plea, then we have the statement. Just because she spoke first, now she's gonna bust the deal?
She's not busting anything. I mean,
I'm
I
the
was coming
victim. I am the victim. How do you even
Please.
speak about? Sorry.
Please.
Yes,
It's
Your
okay.
Honor.
This is a pivotal judicial intervention. Judge Fleischer essentially modifies the deal by adding jail time, signaling that the original agreement felt too light considering what he just heard. Judges can reject or condition plea agreements, and here he's clearly influenced by the victim's statement. Notice the defense immediately pushes back, arguing fairness because their client followed the negotiated deal terms. This moment shows judicial discretion in action. The judge isn't saying the plea is invalid, but he's adjusting consequences to reflect the emotional weight presented moments earlier. And now negotiations resume live in court, something viewers rarely see. Jail time drops from 30 days to 10 days as attorneys scramble to preserve the agreement. But think about it. Should emotional testimony alter negotiated deals at the last minute? Or should agreements remain fixed once reached? Because what just happened changed the defendant's immediate future in real time.
He's been coming to every court date. We've been set for trial 7 times. We're actually set for trial this morning.
In the district court.
I'm sorry,
In the district court.
in felony district court.
I get it. She feels like, one of the things that we need to take into account, is I'm not going to do it without 30 days as a condition. I'm sorry, Joe. So you guys can talk or we can set it for trial. It's your decision, Mr.
You do home confinement?
Home confinement? No. That's a gift. No,
Can we stand up?
please.
Okay. I just want to do 10 days, just 10 days. Otherwise he loses his job.
It's better than the current deal from our perspective.
Okay.
Come on.
And also, Judge, the complainant did not finish her impact statement, if she could be allowed to do that.
Yeah, let me do this first. We'll go through with it and then. So, Mr. Camano, I'm also putting on a protective order as of today. Mr. Camano, you're charged with indecent assault. You're facing up to a year in jail and/or a $4,000 fine. The agreement that you have worked out is a 2-year deferred with thinking for a change, sexual boundaries course, 50 hours of community service, no contact with Ms. Echevarria, and 10 days as a condition in jail. Do you understand?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
You are giving up the right.
Now we enter the technical heart of the plea. Let's break this down clearly. A deferred adjudication means the judge is not entering a conviction today. Instead, the defendant must successfully complete probation terms. If he does, the case can eventually be dismissed without a final conviction on record. But failure to comply? Then the judge can impose up to a year in jail. Conditions here include counseling, community service, strict no-contact orders, drug and alcohol testing, and immediate jail time. These conditions are meant to prevent repeat behavior while avoiding full felony consequences. However, from the victim's perspective, this can still feel like leniency, especially after describing life-altering trauma. So here's a question. Do you think rehabilitation-focused sentences actually reduce repeat offenses? Or should more severe punishment be standard in cases like this? The courtroom may be moving on, but the emotional conflict definitely isn't over yet.
To have a jury decide whether you're guilty or not. You're giving up the right to cross-examine any accusers, confront any witnesses. You give up the right to appeal once you accept this agreement. You can never get out of this. It will continue until you complete this agreement or if you violate it. If you violate it, I will issue a warrant for your arrest. I'm going to bring you back over here. We are going to have a hearing whether you violated this. And if you do, you're looking at an entire year in jail. Do you understand?
Yes, Your Honor.
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
He's a U.S. citizen, Judge.
Okay. I didn't speak to the offense. Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold that for 2 years. You will be required to do the thinking for a change, sexual boundaries, 50 hours, community service, no contact with the complaining witness, no weapons, no drugs, alcohol, random testing. I want him tested in a week, please. If you're using, it's not going to go well. I'm going to tell you now, I'm going to test you like crazy. If I find that you're using, you're going to get a one-way ticket. Do you understand?
Yes, Your Honor.
Okay. Ms. Echevarria, did you want to say something else?
Yes, yes, I'd like to finish my statement, please.
Okay, you may continue, ma'am. Shh.
Okay. Um, sorry, let me get back. Okay. I was 2 years of okay. So I have submitted requests to the HPD, Houston Methodist, and the Forensic Center to access police reports, my toxology, and my rape kit results. All things I should have had years ago. I just began accessing public records on my own because no one helped me understand I had the right to review them. And this is why I wanted to request a continuance. I do respectfully request that the court do require the conditions that prioritize accountability, rehabilitation, and safety, such as formal admission of guilt in court or via stipulation, no contact, and geographic restriction order, mandatory sex offender rehabilitation, and language in the plea agreement affirming that I reserve my right to civil litigation because I want peace and I want to heal and I want to know that my voice mattered. Also, Your Honor, I respectfully request that you do not proceed with that plea until I have had the chance to review the full case file, as well as all the evidence I'm lawfully requesting.
This moment highlights a deep frustration many victims feel, being lost inside procedural timelines. She's asking for time to review evidence, understand her rights, and fully grasp consequences before finalizing the plea. But legally, once parties agree and the judge accepts a plea, reversing course becomes extremely difficult. Courts prioritize finality. Cases cannot linger forever. The judge explains that certain protections she wants, like felony-level counseling mandates, are unavailable now because the case is reduced to misdemeanor jurisdiction. This is where system limitations collide with personal expectations. The law doesn't always provide every remedy victims hope for, especially when charges are reduced. And here's something to think about. Should victims have greater control over plea negotiations? Or would that risk making legal outcomes inconsistent across cases?
Including the police reports, toxology, and stain results. I was not given the sufficient time to revise my statement, and I've had to teach myself how to access the records, the court records, after being left out of the process. This case was reset 7 times in the past month alone, and I was promised a trial, not a rushed plea. I'm asking that the record reflect my objection and that my request for a continuance be considered on the basis of my rights under CCP 56A.051 and 56A.052. If the court must move forward with that plea, I would request the formal admission of guilt, the no contact order, required sex offender counseling, and a clause affirming my right to pursue civil litigation.
What I will say, ma'am, I know that you are upset and I'm sorry that you are. I have no idea why it ended up here, but it is. The lawyers, I think, have been working for a while to try to resolve this. They've come up to an agreement. I did issue a protective order now so that there is one in place.
Thank you.
So, and I've also ordered no weapons as well. So,
Is there any way he can have the sex offender counseling? I feel like very much so.
I don't have, that's not something that I have access to down here. That's only in the felony courts. So I don't get access to any of that stuff.
What about the formal admission of guilt from the defendant?
They have worked out an agreement where they're doing a deferred So it's a deferred adjudication. That's something that you're going to have to get with the office about. I know that you have other avenues of recourse as well. I can't give you legal advice. The only thing that I would probably advise you is just go talk to a lawyer, you know?
And
think
so
that's-
trial is not able to go
There's, no, the
forward.
case is done now. It's ended in a deferred adjudication just now, ma'am.
Okay, and he was previously on the adjudication, but what about, I still feel like I'm being silenced with everything that I've been saying.
You know, the only thing I could advise you is go back to the district attorney's office and just start, talking to people there.
This is the moment of finality, and you can hear how unsatisfied the victim remains. For the court, the case has legally concluded. For her, the emotional process clearly hasn't. Judge Fleischer tries to guide her toward other avenues, like civil litigation, which can sometimes provide financial accountability separate from criminal punishment. But emotionally, closure doesn't come from legal language. She feels unheard, rushed, and confused about how everything concluded so quickly. And this is one of the biggest misunderstandings about criminal court. Verdicts end cases legally, but they rarely end trauma personally. Let me ask you, when legal justice and emotional justice don't match, which one matters more? Because what follows shows the court immediately moving on, even though for one person, the story is far from over.
To the district attorney's office?
Yes, ma'am.
Judge, our first trial setting was March of last year.
Like,
You know,
yeah,
I mean,
I
this
just,
is the first time we're hearing about her asking for anything. And we've
No,
had
I was not,
setting after
I-
setting. Excuse me,
I
ma'am.
was not aware.
Excuse
I
me, ma'am.
have all the
Excuse me.
texts of
Can you
the,
finish, please? We've had setting after setting. This is the first time we've heard anything about this from her. So I don't think that's
this
any.
is not the
part of-
first time. I
Ma'am, let me
have
finish, please.
requested forms before. I have sent
Well, ma'am,
emails
look,
to get these
Mr. Chavarria,
documents and
I
I
don't
was
want to
not
get
granted.
I don't want to get into a big match about what's going on now. The only thing I can say is if you have any kind of disagreements, get back with the office, talk to go to the district attorneys and go talk to them and figure out what else. Like I said, there are other avenues. I can't give you legal advice. I can't tell you what to do from here. Okay?
Okay.
Is that it?
Yes, sir.
Okay. Thank you, ma'am.
Thank you, Judge. Can we start next Friday?
Sure. Yeah. That's it.
Okay, thank you, Judge.
Will the court allow me to consult, the opportunity to consult with the victim advocate
Is there a big?
or a legal liaison
And
before
we have a
anything is
social worker.
finalized?
We have a social worker who is assigned to this case as well, and both of us have been in contact with.
So do you have the number to the social worker, ma'am?
She hasn't been that responsive recently. Just coming up to the court date, really.
Suggest.
I'm happy to give her a call this afternoon and we can go over all of that.
Okay, so the prosecutor assigned to this case will give you a call this afternoon to try to help you get in touch with the social worker to remedy any kind of issues you may have. Okay? If you still have any issues, you can come back tomorrow and then we can try to resolve it further. Okay?
They're at the courthouse.
Yes, ma'am.
Okay, will I be will I be asking for you for your courthouse personally?
You're welcome to, ma'am. Yes. I'm in court 5. You're always welcome to come here and we'll help you out as much as we can. Okay?
Court 5. Okay, and what exactly was the plea that he admitted to, or what is he?
It was a 2-year deferred adjudication
Joe.
with 10 days in jail as a condition.
Okay. Oh, so it went down to 10 from 30? I think I heard 30 earlier. It went down to 10.
Ma'am, I can't continue with this. I have a courtroom full of people that I have to get to. I'm sorry.
Okay.
But I will let you speak, or this afternoon, Gabe is going to call you the prosecutor on the case and he can explain everything further to you, okay?
Okay, thank you.
Yes, ma'am.
Valerie, I'll text you as well.
Okay, thank you.
Thank you. Morning, Mr. Sarna. Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, sir.
And just like that, the courtroom shifts gears. This is the stark reality of busy criminal courts. Emotional cases end, and the next defendant steps forward within seconds. Now we're looking at a completely different scenario: interference with police duties during a capital murder warrant operation. Officers claim the defendant ignored commands and walked toward a dangerous situation. From a legal standpoint, police secure perimeters during high-risk arrests to prevent chaos or accidental harm. Anyone interfering can be charged, even if unaware of the full situation. But confusion appears immediately. Even prosecutors struggle to clarify whether the suspect was actually inside the residence or elsewhere. This confusion matters because probable cause requires clarity. So here's the engagement question. If police order you to stop without explaining why, do you automatically comply? Or do you feel entitled to question authority first? That split-second decision can lead straight into court.
On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle, and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop.
Oh, sorry, sir.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant.
Okay.
Ordered him to stop. He refused to stop going towards the residence, Your Honor.
Did he serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's when this incident occurred.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer and squad 5 of the Houston Police Department's gang division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him off balance and took him to the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what. So I was originally reading the summary. And I'm going straight from the agenda now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that there was that the suspect, that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I don't think
I'm gonna find no probable cause in your case. Just be careful, man. When you get into a pissing match with
I understand.
who's gonna win?
They are. I understand.
No.
Yes, sir.
Hand,
All right. Sit down.
please.
This exchange shows something viewers rarely notice, but happens more often than you'd think. Courtroom scrutiny of police reports. Judge Fleischer pauses the proceeding because the facts presented are inconsistent. First, officers say the suspect was in a vehicle. Then they say the suspect was in the residence. That contradiction matters. Why? Because probable cause, the legal threshold needed to justify detention or arrest, must rely on clear, coherent facts. When officers or prosecutors can't clearly explain what happened, judges can and do question whether charges are justified. And notice the judge's tone. He isn't attacking law enforcement, he's ensuring procedural fairness. Courts are supposed to be the check when facts are unclear. At the same time, the judge still warns the defendant about escalating situations with police. Even if officers are mistaken, physical confrontation almost always ends badly for civilians. Here's a real-world dilemma. When police orders seem confusing or unfair in the moment, should compliance always come first, with disputes handled later in court? Or do people have a right to question authority immediately? Because that split-second decision often determines whether someone goes home or ends up in jail.
You're Christopher Wilkins.
Yes, sir.
Wilkins, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On May 20th, 2024, officers were dispatched to the address of defendant's stepfather. The complainant was stated he confronted his son about missing items. The complainant told the defendant to get ready for rehab. The complainant noticed his jazz bass guitar was missing and observed his neighbor's cameras, which showed his son to leave the house. The total value of that guitar was $480. That was all I have on this one, Your Honor.
Sure, we know he did it.
Your Honor, it stated that there was.
So dad is saying there are several items missing from the house.
Yes, Your Honor, including a guitar.
A bass guitar.
Bass guitar.
Anything else?
Yes.
Does dad call the cops on his own son?
Oh, Your Honor, it was.
Stop.
Oh, my fault.
Stop. Don't
Fault.
say a word. Are you losing? So why talk?
I'm not sure how the police were contacted here, Your Honor. It just says that they met and spoke with the complaining witness.
Another report written like it's just going through a drive-through.
So, Your Honor, the only thing I would say is, she's facing the VIMs. The defendant had initially declined any of the allegations, but later told his mother that one of the items that was stolen.
Judge Fleischer's frustration becomes obvious here. He's essentially saying the police report lacks clarity and care. When judges describe reports as rushed or sloppy, that's serious, because these documents shape whether someone faces criminal consequences. Notice how multiple items are mentioned: guitar, bicycle, other property, yet the official charge centers on only one object. That inconsistency weakens probable cause. The judge is signaling something important. Courts expect law enforcement documentation to be precise. Otherwise, innocent people can be dragged through the system based on unclear allegations. And this case also highlights how minor cases still matter. Even misdemeanor theft can impact employment, housing applications, and educational opportunities. Let's ask something viewers might debate. If evidence is messy but suspicion exists, should courts allow cases to move forward anyway? Or should charges only proceed when documentation is airtight? Because decisions made at this early stage can permanently alter someone's life trajectory.
Which was a bicycle, was later stolen from the defendant when he left it at his store.
But here he's charged with a bass guitar. What the? Have a pet lizard named George. Really? Mr. Wilkins, I'm going to find that there's no probable cause to go forward in your case. This life is a very short life. And when you start racking up convictions, it really hoses you. It's really hard enough as it is as a black man in today's society. And when you start racking up convictions, especially theft convictions where you branded a thief, do you think it helps? No, it doesn't. Get into school, get some knowledge, get a degree, find something to do, and make a lot of money. That's what life's about, not ending up in court with a theft charge. You know what I mean? If you have a drug problem, address it before it becomes a real issue and it takes a hold and grabs you by the boo-boo. You know what I mean? Plenty of people in there. We don't need any more. Please.
Let's step back and look at the full picture of today's courtroom proceedings under Judge David Fleischer. The session began with a long-running sexual assault case resolved through a misdemeanor plea agreement involving deferred adjudication, probation conditions, counseling requirements, and short-term jail time. While legally resolved, the victim's testimony revealed how court outcomes don't always feel emotionally satisfying, even when judges attempt to balance fairness, evidence limitations, and negotiated agreements. We then shifted to a case involving alleged interference during a police warrant operation, where confusion in reporting showed how crucial clarity is when determining probable cause. Finally, we saw a theft charge fall apart due to insufficient documentation, ending with the judge offering personal guidance about avoiding future criminal trouble. These cases highlight the constant tension between legal procedure and personal impact. Courts aim for resolution, but justice often feels different depending on whether you're the victim, the accused, or simply observing. And now we want to hear from you. Did the court strike the right balance today? Should the plea deal have been handled differently? What would justice look like in your eyes? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.